Tonight, our county attorney said the rules are going to change for law enforcement, requiring agencies to disclose more officer misconduct and discipline records to defense lawyers in court cases. Why? Well, it's supposed to keep things fairer in court. John Croman is on our show to talk about what it does. Hi, John.
Hey, Jana, this is a work in progress. It's all about fairness for the accused and about avoiding surprises in trials, making sure the county attorney's office has the latest information about anything that would call a police officer's testimony into question and then sharing that with the defense.
Fair trials are the bedrock of our criminal legal system. If a defendant does not receive a fair trial, a conviction can be overturned.
Hennepin County Attorney Mary Moriarty has stepped up efforts to make sure her office can meet its legal obligations to disclose background information about officers and other professionals who testify in trials.
We really do have this obligation to hand over that information, and so our hope is that when the defense sees that we've got this process and gains confidence in it, they will not subpoena particular officers or departments.
You start with the basic premise that fair criminal trials depend on reliable witnesses, especially police officers who take the stand. And the U.S. Supreme Court in Brady v. Maryland and Giglio v. the U.S. said the defense has to be told if there's anything about the officer's past behavior that would cast doubt on their testimony at trial. Thus, the process known as the Brady-Giglio disclosure.
The data that we have when officers make mistakes, they're held accountable, and in that accountability, it sometimes may show up in trials, and should be, and that brings some credibility to the system. And we, as the county attorney had expressed, and I couldn't agree more, we need to have fair trials, and to do that, Brady's one of the requirements that we have to make sure that we're compliant with.
Brooklyn Park Police Chief Mark Bruley said he's glad the county attorney has included law enforcement in discussions on how to streamline the Brady disclosure system.
We've already received many requests from defense attorneys for exactly the data that the county attorney is now getting from us on a routine basis. And so it already is public data. It's all the officers, all the allegations of misconduct, and all the outcomes. Many defense attorneys have requested it, and I've sent that all to them numerous times.
The county attorney cited a past situation of a suburban officer who had his testimony thrown out in 6 different drug cases, but his own police chief and the prosecutor handling the next case didn't know anything about it.
This office, the county attorney's office, was asked, what are you going to do about this particular cop? And the answer was, we're not his employer. To me, that's unacceptable. We are partners in this. We have an obligation to put on witnesses that we believe will be credible.
Moriarty said 35 law enforcement agencies in Hennepin County have been handing over public data about officer misconduct. And she has added staff to her own team to help make sure that her office is complying with these disclosure rules. And Jana, she pointed out, just because there's a disclosure about an officer, it doesn't mean that officer's testimony is ruled out. Prosecutors can still argue that the officer's past issue is not relevant to the current case.
Now, I'm no lawyer, John, but is this, obviously ensuring a fair trial, is this so in a trial they don't get caught flat-footed on something they didn't know if that comes up about an officer's record?
That's right. You don't want that officer confronted in front of jurors about something that both lawyers should have known already,
okay,
which could cause a pretty tense moment.
All right. Thanks so much, John Croman.